Generally speaking, most practitioners have very strong ethics that drive their businesses. I mean, no one benefits by ripping off clients, certainly not you, and neither the advisors like myself that could possibly jeopardize our own careers through these misgivings. Good day, my name is Neil Gendreau, once again, the Money Doctor. This time we're going to talk about investor protections. These are protections that I find most of the public has very little knowledge of. I think one of the biggest dilemmas I find among the public is, who do I trust? And I think many of these concerns might be better alleviated with an understanding of the regulatory elements that stand behind this industry. It's somewhat complex, but we're going to break this down so you can better understand that there are checks and balances behind this that supports investor protections and also advisor compliance. I think, for better or worse, unfortunately, the public only hears about the exceptions that sometimes slip through the cracks. I think the Bernie Madoff story is a big to-do in many people's minds. But something like this is a rare occurrence and a rare percentage of events that happen in many industries, not only finance. And it's not an excuse, but this is precisely why laws and regulatory entities exist, especially within the financial industry, which is to create and enforce rules, to ferret out bad practices, bad practitioners, and to provide a legal framework for investor complaints. Also to impose fines and expulsions when necessary, to make life fair for everyone. We are definitely accountable. We're accountable to you as our clients. So I think it's helpful to understand that even independent advisors like me, we're all accountable to some type of authority. And it's broken down into two distinct categories, depending upon the classification of the independent advisor. So I'm going to run through these with you now, and I'm going to help you to better understand how this infrastructure works. Some of us operate as registered investment advisors, otherwise known as RIAs. Generally, registered investment advisors with at least 100 million of assets under management must register with the Securities and Exchange Commission, which is the supervisory authority for those particular IRAs. RIAs with less than 100 million in assets under management, they must register with the state in which they're located for doing business. And in that case, the state securities division serves as the supervisory authority. During the registration process, all IRAs must disclose the nature of their financial services, the fees involved, their backgrounds, outside activities, and potential conflicts of interest. In other words, the SEC and the states, they want to make sure that you are an aware investor. This information is provided to you on Form ADV, which must be given to all potential clients. All RIAs, registered investment advisors, are fee-only fiduciaries who must demonstrate placing client interest first, otherwise known as the best interest standard. RIAs, they're also responsible for maintaining books and records that are subject to external audit and review by the supervisory authority of jurisdiction, whether that be the SEC or the state in which they primarily operate. Office inspections are conducted no less than every 5 years and may actually be done without prior notice. So that keeps everyone on their toes. The books and records that all RIAs must keep include check registers, security deposits, outside correspondence, advertising, client communications, email surveillance, technology due diligence, and possibly any complaints that may have been submitted with reported outcomes, whether they were dismissed or settled. But the RIA is fully responsible for establishing its own compliance protocols. In other words, they have to be able to set up the infrastructure and system themselves and must be compliant with the SEC and states. and they must set up protocols for methods of documentation, including for technology, due diligence, and cybersecurity measures. Now, that's a big responsibility. And so there's a second group of advisors who also operate independently, but they're called or they're referred to as investment advisor representatives. That's IAR. And that's the category I fall into. And what the big distinction is between the IAR and the RIA is the IRA reports to an intermediate authority, otherwise known as broker-dealer. The broker-dealer is the financial institution that sets up and maintains the compliance infrastructure that the IAR must fall into. And so why do I do this? Well, I do this because it takes a big burden off my back. I don't want to spend time doing due diligence and research and trying to become a cybersecurity expert to protect my clients. I don't really have time to do that. That takes away from my core competencies. So when I have a broker-dealer do that for me, that takes a lot of time. It gives me back a lot of time to be able to conduct my practice in the areas that I'm most responsible for. That's serving you, the public. Now, both the broker-dealer, which in my case is Kestra Financial Services, both the broker-dealer and myself as an IAR, we're supervised by overall the big caloos are the Financial Industry Regulatory Authority, otherwise known as FINRA. And FINRA is a self-regulatory authority that's funded by both IARs like myself through membership fees, as well as the broker-dealer to be able to guide this compliance infrastructure. And also there are, sometimes unfortunately fines that might be imposed for compliance failures, and FINRA is funded that way too. So those who are supervised by a broker-dealer under FINRA, actually, we also have a little bit more discretion with how we operate our businesses than does an RIA. An RIA can only charge fees as a fiduciary, but those who are considered what's called the registered representatives with a broker-dealer can operate either as an IAR, they must qualify, I'm going to get into that in a moment, or under commission-based business, which is not subject to the fiduciary standard, as a registered representative. So IARs, like myself, we have separate credentials and qualifications that require us to operate as fiduciaries when we do fee-based business. And those qualifications include the following fiduciary designations, which are either the CFP, Certified Financial Planner, ChFC, Chartered Financial Consultant, CFA, or having passed the Series 65 FINRA exam. Actually, CFA is Chartered Financial Analyst. Excuse me. It's either those designations or passing a Series 65 exam through FINRA, which allows us to operate as IARs. Well, as I said, the registered representative, if I were to choose to do commission-based business with a client, maybe because it's not so much of a thorough process, given what the client is looking for in terms of, investing money. They just want some superficial advice and a recommendation. They're not doing financial planning. They're just trying to get their money working a little bit harder. I can decide to do commission-based business. Those are subject merely to suitability standards, which means that the recommendation cannot be harmful to the client, but they're not necessarily best interest recommendations, which follow a fiduciary standard, unless the commission-based business has to do with a retirement plan, such as an IRA, which does require fiduciary treatment, but it could still be done on a commission basis. I know it's a mouthful, it's confusing, but that's exactly my point. It is confusing. So to eliminate this type of confusion and to facilitate the greatest amount of trust and consistency with my clients, very rarely, if ever, do commission-based business. If a client wants only that type of superficial advice, I will most often refuse to do business with them. unless it falls under an exception. It was someone recommended to me. Maybe it's a young kid with just trying to, get an account going. They don't meet the minimums for a fee-based account. Otherwise, 99.9% of the time, I'm operating my business as an investment advisor representative, IAR. And because I operate almost entirely as an IAR, I'm subject most often to the fiduciary best interest standards consistent with the best professionals that you can count on. So, like RIAs, if you might recall having just discussed that, IARs, like myself, we must also provide a Form ADV, which is similar to that of the RIA, for all fee-based business that we do, which discloses the nature of the agreed-upon financial services, the fees involved, my background, my outside activities, and potential conflicts of interest. And so here again, just to reemphasize, the difference of my model versus that of an RIA is that my compliance standards are enforced upon me. They're not chosen. I don't create my own compliance infrastructure. I'd rather not, because to me, that's all administrative and has nothing to do itself with financial planning. I mean, I recognize the need for compliance procedure, but I don't want to design it. That's the point. So Kestra does me a great favor by designing that infrastructure for me. And they give me a platform to operate under to be able to run my business, which they review all the technology that I use in advance, that it meets and follows the best standards of practice regarding cybersecurity, regarding confidentiality of client information, and also any particular surveillance that might be required for correspondence. However, just like an RIA, I still have to maintain my own books and records to demonstrate that I'm following the rules. But outsourcing the due diligence of these vendors that I use makes my practice far more efficient. And that way I can focus on working with you rather than trying to memorize a bunch of rules or creating infrastructure designing the rules themselves. Spare me the trouble. And to give you an example of this video that I'm doing now, I just can't take this video and put it on social media randomly without permission. This video is being filmed. It's going to be submitted to my compliance department before I actually publish it. And once my compliance department approves the video, they'll also monitor it where it's published to make sure that it's the same video, obviously, right? But here again, this is just an example of, it's kind of tight. Some people might look at it as onerous or an intrusion. Frankly, I wish we didn't have to go through this degree of monitoring, but I do recognize the necessity for it. And so I'm more than happy and willing to comply, because at the end of the day, I have to comply to someone. I want to make the compliance as streamlined and as far removed from me in terms of the design as possible. But I do respect the rules. Even if I might disagree with some of them, I don't argue about it. I follow the rules, and that way it keeps me safe. It keeps Kestra Financial Services safe, and we have a mutually beneficial business relationship along those lines. Of course, Kestra takes a slice of my business for providing that to me, but that's something I'm willing to pay for, and that's really the trade-offs of running any type of business. You have to be able to select your best poison, I guess. But as an IAR registered representative, as I am, I'm subject to compliance inspections every 2 years, conducted by my broker-dealer, Kestra, and sometimes on a surprise basis. They may not even tell me they're coming. They just come. Also possible inspections by FINRA, like if I was suspected of any foul play or wrongdoing or grotesque compliance infractions, then they could come in my office and check things out. But that's never happened. But it's possible. The point is I'm held accountable. And so regardless of, how we advisors decide to affiliate, whether it's RAAs, IARs, unfortunately, when we deal with the public, sometimes there are areas of contention or disagreement that come up legally. And all of us, we're all subject to the possibility of complaints, lawsuits, and litigation, for which we have errors and omissions insurance coverage that covers, a big dent of any potential lawsuit if it becomes exceedingly large. But we're still held accountable. Just because we have coverage doesn't mean that we can keep on suffering these infractions. And so most hearings are conducted through a process known as arbitration, which simply is a non-public hearing. It's conducted by the authority of jurisdiction, whether in the case of an RRA, it could be the state, could be the SEC, or in my case, it's FINRA. And so the difference in having a public hearing for any complaints or lawsuits is that it tends to keep things confidential and quiet, which is probably best for both parties. Because a lot of times people don't want to let everyone know about their business. And yeah, it does put a stain on both the registered representative and possibly the broker-dealer. But nonetheless, these are reportable events that are actually reported on our record so that the public can check this out, any investigations that might have been done, what the outcomes were, whether there are any fine censors or suspensions involved. But despite this, as a result of such a hearing, if the RIA, IAR, or broker-dealer, if any of these parties are found responsible, any could be subject to not only the settlement legally, but also fines imposed by the jurisdiction of authority. Could be fines, could be censorship. That means a public release of the outcome. Could mean a suspension of the advisor and termination of their contract. So the point is that we are held accountable for our actions. And if any client feels that were not well served, that they were misled, or if they're entitled to some type of compensation for their loss, then they can actually go through this system of arbitration to determine whether that might be the case. And these are for civil cases, but if there are criminal charges involved, those can also be filed separately, and all criminal hearings are held in a public court of law. So not only do we have to uphold regulations, but in order to ensure that funds aren't misappropriated, like when you make contributions to your investment accounts, where does that money go? It doesn't go to me. I don't put it in my account. If it goes, if I work with someone like ChFC Financial Advisors, ChFC doesn't cash the check either. We all have third-party custodians that are responsible for receiving funds, holding funds, and providing information and statements to all the account holders of record. So the separation of duty makes sure that the cash is held away from any type of intermediary like myself that potentially could abuse their authority of those funds. And we don't want that to happen. So that separation of duty makes things a lot more clear and distinct, and makes sure that we don't take actual possession of your money, that it's done by third party. And so when I get a check, for instance, like if you send me a check to make a deposit to your account, that check is made to our third party that we use at ChFC, which is National Financial Services, or NFS. And I actually have to send an electronic copy of that check to NFS to have that deposited to your account. Or let's say if you're transferring money from a retirement plan at work, etc., that goes directly from your retirement plan to NFS, not to me, not to ChFC. But all these checks, they're recorded electronically, and I never personally hold your cash, neither does ChFC, nor does any independent RIA. So these brokerage accounts are established at custodial firms who provide all the services that you need for clearing, for accepting the funds, for dispersing funds if you take withdrawals, and for maintenance services on your behalf, like providing statements. And that's where your money is held. But most importantly, the securities industry itself provides what's known as SIPC insurance coverage. That SIPC stands for Securities Investor Protection Act. That coverage is for up to $500,000 for every eligible account registration, and under each eligible account, up to $250,000 of cash can be protected. So eligible account registrations include individually owned accounts, jointly owned accounts, trust-owned accounts, and IRA accounts. So, for instance, you could potentially have, if you had each of those categories, each of those four categories, you could have $2 million of your account values protected by SIPC and up to $1 million of cash held in those accounts. Now, that protection is very distinct. It's not like FIDC at the bank. It doesn't cover losses due to market value volatility or changes in market value. I want to repeat that and make that perfectly clear. SIPC does not insure your account from investment losses. The purpose of SIPC coverage is to protect against insolvency or fraud. So, as I mentioned, like when your account is held by a third-party custodian, those assets are not the assets of either Kestra or the custodian. They're your assets held individually. But in some cases, some of you might be familiar with trading on margin, which means that simply you could borrow money to buy and sell securities. Those accounts that are held on margin, the securities that you deposit in those accounts, they could be hypothecated, which means they could be lent out to other people who are taking margin loans for things like short sales. And it's that type of liability that could cause a bankruptcy that interferes with the value of your account, but it's more often due to protection against fraud or misabuse of your money. But generally speaking, the SIPC gives the investor greater confidence in the presence of where their brokerage account and securities are being held, that they are there, and that they are covered in the event of either of those two exceptions that might apply to the security of those assets. So that gives you some further consolation, knowing that there are many layers of regulatory protection against your accounts, not only by laws and rules of how we as advisors must operate, but equally as important, protecting your money from disappearance. Okay? So this is a pretty good summary of all the things that give investors more protections that they might be aware of. And I think what's important to understand is that, generally speaking, most practitioners have very strong ethics that drive their businesses. I mean, no one benefits by ripping off clients, certainly not you, and neither the advisors like myself that could possibly jeopardize our own careers through these misgivings. Unfortunately, there are always outliers that represent the exception rather than the norm, and unfortunately, people hear more about the exceptions than what happens 99.9% of the time. The reality is that failures of supervision sometimes occur, even from the regulatory organizations that enforce those same rules. But you can also understand that a solid infrastructure is in place for compliance, for regulation, and for enforcement. And privacy rules also apply regarding the disclosure of your personal information. I can't just send that out to anybody, only affiliated third parties. Like NFS is the custodian to your account, is going to have the same information I have about you. Hopefully, this has been a helpful tutorial that's been useful. Maybe it gives you better peace of mind if you're debating and working with an advisor. Definitely you need to find someone you can trust, but you should be able to trust someone at the very least by their professional experience and credentials. And then, of course, if you're introduced through a referral, or if you've been watching my videos for any sort of time, or receiving my emails, if you've looked at my website, you can put all these things together and understand that I'm operating a legitimate and useful business that many of my clients are very happy to participate with me in. So I hope that's been useful info. And if you found it to be useful, please do me a favor to like and subscribe to this video. That way it gives more visibility to the public, and more people might be able to watch it based upon your recommendation, which I always appreciate. So thank you very much for your attention. And this is Neil Gendreau, the Money Doctor, signing off. Have a good day. Neil Gendreau, and these videos are not intended to provide specific investment or financial advice. Please contact your own financial advisor if you have one, or if you don't, why not contact Neil?